Welcome to the Silverbridge CPA's Summer Speaker Series. We hope you enjoy this message.
I think we'll go ahead and get started. I know, people are busy, so I want to be respectful of your time. But hello to everyone who's joining us. I'm Brittany Williams. I'm Silverbridge CPA's firm administrator, and we're happy to have you here for our third summer speaker series. We're very fortunate to have attorney Jon Bauer here with us today, sharing his knowledge on a will-based estate versus a trust-based estate, and how to choose the best one for you. I'll introduce him shortly, but just a few items to go over first. If you haven't already, please be sure to mute yourself and keep it muted throughout the presentation. You can do this by clicking the microphone in the upper right corner of your screen. This presentation is being recorded, so if you don't want your face to be on it, please turn your camera off now. And then you are welcome to type your questions as you have them into the chat feature. And then at the end of the presentation, we can go through those, and Jon will answer as many as possible. And then if we have time, we can also just open the floor up to questions from you guys, and you can do that by simply unmuting yourself. With that said, I will introduce our speaker. Jon is a partner at the boutique law firm of Tyree, Bauer, Baldner. Jon and his partners focus on helping clients and their families stay out of trouble by advising them before the bad things happen. This includes, in Jon's case, helping clients set up their estate plans. For Jon, estate planning isn't a cookie-cutter process with every client getting the same plan. Jon spends time with his clients in order to assure they get an estate plan that suits them. He helps clients develop their own list of goals and objectives and uses wills, trusts, business entities, and other legal tools to implement the right estate plan for each client. A brief review of this process and some of the key issues will be the topic of discussion today. All right, Jon, I will turn it over to you.
Thank you so much, Brittany. Can you hear me? I'll start in advance by apologizing for any technical difficulties. Brittany's been walking me through the Teams meeting process. I'm not super awesome at it, but hopefully all goes well. I want to first of all thank Silverbridge for having me. One of the things I always talk to people about when I talk about estate planning, and frankly all the other legal stuff that I do, is you need good accounting help throughout the estate planning process. Whether you're running a business, doing real estate, or just simply trying to make sure your estate planning and financial affairs are in order, having a good accounting firm like Silverbridge helping you is vital. So thanks to Silverbridge, and thanks to you all for coming here online today and listening to my little spiel. I will tell you that really, as Brittany suggested, this presentation we're about to go through together, it's really sort of a condensation of the first meeting I have with virtually all of my estate planning clients. What I'm looking to help my clients do is to figure out what's important to them, understand what it is they have and what their goals are, and then help them decide on what the best estate plan is for that particular individual. So I view it as a very personalized process, and it's worth spending the time and energy making sure that it works and helps people meet their goals. So the title, The Best Estate Planning Approach for You, is truly that, which is what we try to do is figure out what works for every individual client. So with that said, you guys already know who I am. My firm, as Brittany suggested, is a boutique law firm. We don't do litigation. We don't do slip and fall work. We don't do family law stuff. We do, primarily commercial real estate transactions and help people with their real estate issues. We do general business law, help people start, run, sell their businesses. And then we do this estate planning and probate work, which frankly, on some level, is some of my favorite stuff. I just like helping individuals get the comfort that they need, knowing they have the right estate plan for them in place. So let's just dive right in. We'll, again, we're going to talk about sort of an estate planning 101. And what that involves in my mind is primarily sort of two things. One is, we're focused on a fundamental estate plan. And what I mean by that is sort of everybody needs one of two types of estate plans. And we're going to talk in a fair amount of detail about those two types of estate plans. And then what is a necessary part of that discussion is also the concept of probate. And so helping people understand probate, help them decide whether or not that's something they want to avoid, whether or not it's a scary thing to them, or they just simply don't like the idea. That's an important part of all your estate planning discussions. So those are basically the two things we're going to focus on, the two types of fundamental estate plans, and then a discussion about probate. So here are the two types of what I call fundamental estate plans. You can have a will-based estate plan, and you can have a living trust-based estate plan. So that's sort of the first conversation piece I have with all of my clients when we're starting to think about what kind of plan suits them. Just briefly on this living trust-based plan, we're going to talk about sort of two different types of trusts today. This living trust is the primary one we're going to talk about. It's also called an inter vivos trust, and that means just a trust you create while you're alive. That's why we call it a living trust. The other type of trust that you hear a lot of talk about are called testamentary trusts. Those are trusts that don't spring to life or don't come into existence until somebody passes away. So it can be a little confusing. In a will, for example, you can have a trust that gets created for minor children once you've passed away. That's a testamentary trust. You can have that same type of trust in a living trust-based plan. So testamentary trusts can be included in both a will-based plan or a living trust-based plan. So again, these two different types of trusts. One is a living trust, which we're going to talk about a fair amount here. These testamentary trusts we'll talk about a little bit less, but I just wanted to make those distinguish those two types of trusts. So I talk to my clients. Do you think you want a will-based plan or a living trust-based plan? Let's talk about that. In order to get there, we're going to talk a little bit first about what the different tools are we use for people in estate planning to accomplish their goals. So wills. We talk about wills and what they do. And your wills, you can have these testamentary trusts for children or spouses. You can do tax planning in wills. So wills are one of the tools we use. The living trusts we talk about, those are trusts that we create, again, while somebody is alive. And really what living trusts are fundamentally geared towards doing is avoiding probate. That's basically what a living trust is designed to do. Some other tools we deal with in estate planning are certain other types of living trusts. I listed a few here. An ILIT, that's an irrevocable life insurance trust. Not going to go into those in detail, but basically what those are, they're fairly common. They're designed to hold life insurance policies so that the proceeds of those insurance policies don't end up in the deceased person's estate. A SART, standalone retirement trust. Those are very specifically designed to own or be the beneficiaries of retirement plan assets. Not going to go into a lot of detail, but that's another type of trust. Special needs trust for somebody that's an SNT, for somebody who's on Social Security disability or other disability benefits. So there's lots of different types of trusts. We're going to be focused on that general revocable living trust, but I just thought I'd mention some of these other trusts or tools that we use. And then a few other things just worthy of mention, and we're going to talk about some of them a little bit more later. Durable powers of attorney. We do those for virtually all of our estate planning clients. That's where you name a financial, a person to do financial things for you, typically if you can't do them yourself. And then healthcare directives. We're going to talk a little bit more about that. And then I mentioned family limited liability partnerships. That's an FLLP, or family limited liability company. That's an FLLC. And those are basically, typically we use those in estate planning for tax planning tools. I'm not going to go into a lot of details, but as you can see, there's a lot of different tools we use for people in their estate planning, and it all comes down to what their goals are and what their needs are. So let's initially start talking about the will-based plan. Again, and I repeat myself a lot because I just find that it helps clients sort of digest and understand the information. Two types of fundamental estate plan, a will-based estate plan and a living trust-based estate plan. We're going to talk about the will-based estate plan first. So how does a will-based estate plan work? Well, I'm going to use a married couple for an example, our primary example. So in a will-based estate plan, each spouse has a will. And the will might say something like, if I pass away first, then I leave everything to my spouse. But if my spouse has predeceased me, I leave everything in trust for my kids until they're 30, and then they get it all. So, you know, in that case, you have each spouse has a will. They usually mirror each other, typically. And the real will has all the operative provisions about who gets what when. But keep in mind that a will does nothing until somebody passes away. It sits on a shelf and collects dust until somebody passes away. And even then, it doesn't do anything. It can't do anything. It is not legally binding until it goes to probate. So a will, in a will-based plan, each spouse has a will. Each will deals with that spouse's half of the property, and the will doesn't do anything unless it's probated. So those are some of the key sort of aspects of a will-based plan. I will add that one of the most important parts about a will for people who have minor kids is that's where you put the guardianship provisions. And that's one of the most important things for couples with minors, you know, why they should get an estate plan done ASAP if they don't have one. You'd rather pick who is in charge of your minor kids than have some court do it without knowing what you wanted. So really important. So that's sort of the beginning of a will-based, you know, what a will does and the fact that the will requires a probate in order for it to be implemented. Also in a will-based plan, we always have healthcare directives for people. And then we always have a durable power of attorney. Let me spend a little bit of time talking about the healthcare directives and the durable power of attorney right now real quickly. Healthcare directives, we basically use, as you should use, the Idaho statutory form. There's two parts of that form. The first part is where you let the world know what your wishes are about the care you would like your body to have if you're in a terminal condition. It's not fun stuff to talk about, but I go through it with clients, explain things, and you have to make some choices about what kind of medical care you want if you're in a terminal condition. Very important document for pretty much anybody to have. The second part of your healthcare directives is still part of the healthcare directive statutory form that the Idaho legislature has adopted, is where you name a healthcare agent. Who is it that will make healthcare decisions for you in the event that you cannot make them yourself? So we help people get through that, name the people they want to make those decisions for them. The financial durable power of attorney, typically we do those as what we call a springing power of attorney. In a springing power of attorney, what all that means is that it isn't effective unless you are disabled. So here you're naming somebody to take care of financial things for you, file your taxes, sell property if you need them to, deal with investments if you are disabled. You can do a financial power of attorney that is an immediate one. It's immediately effective when you sign. Typically, we don't do a lot of those unless somebody is, you know, kind of imminently sick or needs that type of help right now. So will-based plan, each spouse has a will. So you got two wills, then you have your healthcare directives, and then you have your financial durable power of attorney, typically springing, meaning doesn't take effect unless you're disabled. So that's a real broad outline of a will-based estate plan, and we're gonna get back to how we help clients choose which is more appropriate. But before that, let's go on to our living trust-based estate plan. So what does a living trust-based estate plan look like? Well, instead of having two wills that have all of the substantive provisions about who gets what when, we have one living trust agreement. And again, I'm just going to presume for argument's sake that we're talking about a married couple. We can do it for single people too. We do it all the time. What a trust agreement, there's three key roles in a living trust agreement. There's the grantor, and that's the married couple who are putting the assets in the trust. They own all the stuff and they're putting it in the trust. We have also the married couple who are the trustees, meaning they get to control all the stuff in the trust. And then again, we have the beneficiaries, and in a revocable living trust-based plan, the married couple is the beneficiary. So they're actually they hold all three jobs, all three roles. And this living trust agreement talks about who gets what when for both spouses. So it will say something like, when first spouse passes away, everything goes in trust, everything that belonged to the half of the stuff that belonged to the first spouse to pass away, that all goes in trust for the second spouse. And then when the second spouse passes away, it all goes into a trust for the kids until they're 30, and then they get it outright. So all the operative provisions aren't in the wills, it is in the trust agreement. Also in a living trust-based plan, we do have wills, but the wills are really just designed to capture any assets that aren't in the living trust when somebody dies. So let's talk a little bit about that. So in this living trust-based plan, we create this living trust, and John Doe and Jane Doe are the trustees and the grantors and the beneficiaries, as we just talked about. So as trustees, what we'll do is we'll retitle most of their assets from John and Jane Doe, husband and wife, to John and Jane Doe, trustees of the John and Jane Doe Revocable Living Trust. We'll help them move their bank accounts in there, their real estate, some other assets. And so they still own and control all that stuff. It's just owned by them. Technically, we've retitled it as trustees. And so that way, as trustees, they control all those assets. And when one of them passes away, they don't need to retitle everything like you do in a will-based plan. Now, what happens if they sold a house, bought a new house, and they didn't name themselves as trustees? They just put it in their own name. Well, that's when this pour-over will comes in. It's sort of the belts and suspenders. They pass away, you just probate this little pour-over will. It doesn't have all the operative provisions about who gets what when. All a pour-over will says is, if I die and I accidentally didn't have something in the trust, please put it in the trust. So then it gets retitled in the name of the trust, and then the surviving spouse as the trustee controls those assets. We also do have a financial durable power of attorney. One of the other things that a living trust does is, because both spouses are trustees, if one spouse becomes disabled, the other spouse has full control of the assets because they're already the trustee. And so it makes it easy for somebody to manage assets for the disabled spouse. And we're going to get back to that a little bit. But what the durable power of attorney does, sort of like the pour-over will is belts and suspenders if somebody dies and something's not in the trust, the durable power of attorney, financial durable power of attorney, is the belts and suspenders if somebody becomes disabled and an asset isn't in the trust. So really what you're hearing is, with this revocable living trust-based plan, to really make it work the way you ideally want it to, you have to have your assets retitled in the trust. We help people do that initially, and then we help them understand how to continue to do that as they go down the road with their lives. And then, of course, in our living trust-based plan, we also have healthcare directives. So again, to summarize the documents that we have in a living trust-based plan, we've got the key revocable living trust agreement for the spouses, for both spouses. Then each spouse has a pour over will. It's just a little will that says if I die and something wasn't in the trust, put it in there. Then we have a financial durable power of attorney for each spouse. Again, if I'm disabled and something accidentally wasn't in the trust, giving my spouse the ability to manage that asset and get it in the trust for me. And then each spouse has healthcare directives. So those are sort of the key documents. I'll continue on. Feel free to jump questions in there. If I see them, you know, I'll try to hop on them and answer. Otherwise, I'm happy to just answer them at the end. So now, as I've talked with my clients about these tools that we have, wills, trusts, and healthcare directives, and financial powers of attorney, we start to narrow down. Okay, well, why might you want one of a living trust or a will-based plan? And so I'm going to start here on this slide with this living trust. So why might you not want a living trust? Well, as I said, the goal with this living trust is once you set it up now while both spouses are alive, you want to keep all your assets titled in the name of the trust. That is how it works to avoid probate and how it works to help if a spouse becomes disabled or both spouses become disabled. So as you go down the road and your life changes and you move houses and you change banks or change investment accounts or whatever, you have to really try to make sure that everything continues to be titled in the name of that trust. It's not the end of the world if you don't. You have that pour over will to collect assets and put it in the trust if you die. You have the financial powers of attorney to do the same thing if you become disabled. But it sort of defeats the main purpose of the living trust if you don't live, as I say, the trust life and keep things in the trust. For most people, it's frankly pretty similar. Their lives aren't that complicated. Their financial situations aren't that complicated. But for some people, they just don't feel they're organized enough or don't want to do that. And so they're not interested. The other thing why you might think I don't really need one of these living trusts is in Idaho, probate is really not that complicated. Some states it's horrible. California is the most notorious. Everybody in California has a living trust because, again, primary purpose of a living trust is to avoid probate. In Idaho, typically not that complicated. We'll talk a little bit more about it, but you might decide, hey, I don't need the rigmarole of a living trust because probate's not so bad. The other thing, as I mentioned, if you forget a key asset, you might end up having a probate anyway. So you spent some extra money and some extra time up front for this living trust-based plan, but you miss an asset. Well, I end up having to probate anyway to get that asset in the trust. Why did I bother doing a living trust? So that could be one reason. Another reason is, you know, aside from avoiding probate, you can do pretty much anything with a will that you can with a living trust. You can still do any tax planning you need. You can still create trust for your spouse if you're the first to die or for your kids. So some people think, yeah, I don't mind the probate. I can do all that other stuff with a will anyway. I'm just going to go with a will. The other thing I'd mention is one of the things that most often triggers probates is real property. So if you have a married couple and all their bank accounts are joint with survivorship and their life insurance name the surviving spouse as a beneficiary, retirement plans name the surviving spouse as a beneficiary, you know, when the first spouse dies, you can avoid probate even without a trust if you have all these automatic transfers set up. But real property usually gets people. But there is this thing under Idaho law called a community property deed. And for our will-based plan married couples, we will often do this. And it's just this special deed you need to allow property to transfer automatically to a surviving spouse. If your deed just says John Doe and Jane Doe as husband and wife, it does not automatically transfer. That confuses a lot of people. You have to have this special deed. So why not a living trust? Well, I can have a will, I can have all my bank accounts be designated as survivors, don't mind probate if I get stuck with one, and I can have John do one of these community property deeds for me. So when the first spouse passes, you know, everything can just go to the surviving spouse. I probably don't need a probate anyway. And then the surviving spouse can make a decision about, you know, whether to do a living trust, you know, once they're around. So those are some reasons why you might not think a living trust is for you. Why might you want to do a living trust? Well, maybe you don't like the idea of probate. We're going to talk a little bit more about those, about probate. There is a cost to it. The other thing is if you own real property in another state outside of Idaho, and it's in your own name, not in an LLC or not in a living trust, you actually have to do an ancillary probate in that state. Well, in Idaho, probate's not bad, but depending on this other state, could be a little bit bad there. Plus, that means now you're doing 2 probates. That's more expensive, more hassle. You know, so you might seriously consider a living trust-based plan if you have real estate outside of the state of Idaho. Then there's privacy issues with probate. We're going to talk a little bit more about that. You might be worried about a contest. You know, people always come in thinking that their family situations are unique or particularly bad because there are issues. It's not unusual for a family to have an adult kid that they don't have a relationship with anymore. They decide they're not going to give anything to that child in their will, worried about a contest provision. Will-based plan where you're having probates, you know, probate can make it a little bit easier for somebody to contest a will or cause problems. And so, you know, some people would prefer a living trust-based plan if they think maybe somebody's going to fight the will or complain about it. And then the last thing is I mentioned, and I see a question pop up. I will address some of these questions shortly. So yeah, so those are some of the reasons why you might want to avoid want to avoid probate and use a living trust-based plan. And again, I'm going to talk a little bit more about probate in a minute. 2 questions I'm going to hit just while we're going here. I want to make sure I get to the questions. In some ways, those are the most important. Somebody asked, if I live in Idaho for 6 months and Arizona for 6 months, does it matter which state I do the trust in? Well, the state in which your estate plan is based, it should be the state in which you sort of consider yourself as living. And I know, and that there is some gray area there. So what I tell people is, you know, generally the place that you get your mail is, you know, your sort of default address for places like the IRS or other sort of important mail, you know, type things. That's really what your domicile is, and that's really where your estate plan should be done. And to be clear, I do estate plans for people who are domiciled or, you know, consider themselves to reside in the state of Idaho. I'm not licensed to practice in most other states, only Massachusetts, and I don't even do estate plans there because frankly, I'm just not up on the estate planning laws in Massachusetts. I don't do much work there. Somebody also asked, if I have my son on my bank account, do I have to put it in the trust? Well, that's a question that's going to depend on what your goals are. What is your goal of having your son on a bank account? And I will add, and this is something that I talk about with all of my estate plan clients, and I really encourage them to do as we're going through the estate planning process, is you want to go back to all of your bank accounts and confirm with your bank, how is this titled? I have my spouse, or I have my son, or I have somebody else, in quotes, on the account. Well, what I have found in the years that I've done this is people don't always understand. There's lots of different ways these financial institutions do these, set up these accounts. So if, for example, somebody has their son, in quotes, on the account, Well, the account could be jointly owned with the son. The son could just be a signer on the account. The son could be a signer and have the account payable to the son. It could be any combination of these things. And it's really important in the context of your estate planning to go back to your bank, and I work with my clients to ask the right questions so that we know how all the accounts fit in with the estate plan. And by the way, the same thing is true with life insurance, and the same thing is true with retirement plans. I always say, let's go back, get your beneficiary, your current beneficiary designation forms from your financial institutions on retirement and life insurance. Let's take a look at what they say and make sure that they fit in with the plan that we're trying to put together for you to meet your goals. So hopefully that's at least a beginning answer to those two questions. And I'm going to move on to a little bit more of a detailed discussion about probate. So there's a few forms of different forms of probate. The vast majority of probates in Idaho are what we call informal probates. They're basically a paper pushing process that involves, so John and Jane Doe, John Doe passes away, there's a will-based plan, Jane Doe brings the will into the lawyer, they basically just put some paperwork together, they both sign it. Preferably it's the original will, but it doesn't even have to be the original will. It doesn't make it that much more complicated. File it with the court, and the court basically does two things. And this is basically what probate does, what probate is. The court looks at the will and says, oh yeah, that looks like a legitimate will completed pursuant to the laws of Idaho. I accept it as valid and I take it into probate. And then the other thing, which is fundamentally the second and only other real key thing for probate, is the court names the personal representative. And that's almost always just the person who's named in the will. We call them personal representative here. A lot of people think of them as executor. It's the same thing. It's the person who's in charge of doing what the will says they're supposed to do with the assets. And that's basically probate. I always tell people it typically costs, just to get to that point where the court's approved it and named the personal representative, typically costs less than $1,000, typically takes less than a couple weeks from the time that you come in to see the lawyer until the time you get the permission. And then from there, it's just a matter of how much help the personal representative may need from the lawyer to change the title to the house, to leave the gifts to the grandkids, to do whatever it is the will says. Sometimes there's not a lot and it's not very hard and the lawyer hardly does anything. And then sometimes people need quite a bit of help. But typically an informal probate process is pretty easy. But why might we avoid it? And remember, the way to avoid the probate is by having a revocable living trust-based plan, typically. Well, there is that cost to it, although I will add that at least in my practice, a living trust-based plan is about $1,000 more on average than a will-based plan. So in some respects, you're sort of paying more now or more later. But there is this cost to probate, even though it's not a great deal. I talked about the worrying about contests. So one of the things you have to do when you're named a personal representative of an estate is you have to provide notice to anybody who gets things in the will, and also to anybody who would have gotten something if there wasn't a will. That's what an heir is. Idaho law provides that if you don't have a will, certain people get things, your spouse, your children, etc. Well, those people, even if you have a will, have to get a notice when the personal representative is appointed by the court. So say you cut Joey out of the will, your adult son who you don't have any contact with. You had a will, he's not in it, he's specifically excluded, but you pass away and a personal representative's named. Well, Joey gets notice of the probate. And some people feel, and maybe there's some legitimacy to it, that I don't want him having to get notice. Well, a living trust-based plan is a way to avoid that. And I would add there's some reasonableness to that. Once you open up a probate, there is already a legal action there. There's a case open with the court. It's there. it's waiting, and it makes it a little bit easier for somebody to jump in. If you have a living trust-based plan and you don't have a probate open, that person A doesn't get the notice, and B would have to sort of start a brand new legal action to make a complaint about it, whatever that complaint would be. A little harder, a little more expensive, maybe less likely somebody makes a stink. Also, in a probate, personal representative has to do an accounting. That's just basically a balance sheet of the deceased person's estate. Typically pretty simple, pretty straightforward. Also, there's this idea that you necessarily have to, file that with the court, and it becomes a public record. Anything that's filed with the court, including a will, is a public record. But the accounting does not have to be filed with the court. What the law says about the accounting, and again, it's just a balance sheet, assets and liabilities of the estate, is that if an interested person asks for it, they have to be provided a copy, or you have to file it with the state, with the court. So, often not a big deal, this accounting thing. When I said interested person, by the way, that's these heirs. It's also anybody who gets anything under the will, whether or not they would be an heir under the law. And it could also be creditors of the estate. So, some people don't like the idea necessarily of having to do that accounting. And then there's this notice to creditors. You guys may have seen when you file a probate, oftentimes, most of the time, you'll see a newspaper that says so-and-so has passed away. Here's a notice to any creditor. If you think you have any claim, show up within 4 months of the date of this publication. Otherwise, you can't ever make a claim. So some people don't like the idea of publishing those notices to creditors. I can understand that. At the same time, there's a real good side of doing it. The good side of doing it is, say you owed somebody money under a promissory note you signed for them. You borrowed money from them. Well, typically, from the due date, there's up to 4 or 5 years which they can come back and make a claim against you. If you've passed away and they have a claim and you file this notice, they've got that 4 months, and that's it. So what happens is it cuts off creditor claims quickly. That's the upside of publishing that notice in the newspaper. So sometimes we'll have a living trust-based plan. Somebody will pass away, all the assets are in it. We don't need to do a probate for any assets at all. But sometimes we'll actually do a probate just to file that notice to creditors to cut off all those creditor claims. So those are a few of the issues with probate and why some people might want to avoid it by using a living trust-based plan. I also mentioned that a living trust-based plan can help with disability. And I'm not going to spend too much time on this. We talked about the durable power of attorney. Really, the idea is if you feel that you have certain disability concerns, either because of age or an illness, or you just had a family experience where somebody became disabled and it was really complicated for the family, then a living trust-based plan can help you get all those assets in the living trust. So let's say you're a single person, older person with an adult child you want to have help you. Well, you get everything in the trust, you name that child as a successor trustee. If you become disabled, they can quickly and easily slide in to help you. If you don't have a living trust-based plan, it's a little bit more complicated for that adult child to kind of step in and help you with your assets. So again, disability concerns, living trust-based plan can be really helpful. Since it's about 1/4 and I want to give people time for questions, I'm going to skip. We can define disability in all sorts of different ways in our living trust, and these are just some of the different ways we can do that. I'm going to sort of skip through that and get to what I go through this with every single one of my estate planning clients. After we've talked about a will-based plan and a living trust-based plan and about probate. Okay, so let's get down to the sort of checklist on what are the things you look at to make a decision. Well, I already said if you have real property out of the state, of Idaho, that sort of points you towards a living trust-based plan. Because if you have a will-based plan, you got to do 2 probates in 2 different states, more complicated, more expensive. Do you have disability concerns? If you do, you might lean towards a living trust-based plan because it's easier to manage assets in a living trust for a disabled person than if they're not in a living trust-based plan. Do you not like the idea of probate? You got a concern about somebody contesting or making a stink, or you don't want to have to necessarily do that accounting, or whatever it is, it doesn't appeal to you. If you don't like the idea of probate, that's what a living trust-based plan is for. And then the last thing is this living trust-based plan. What we do with clients when we do them is we help them sort of gather up all their assets. We help them retitle it. We give them a binder and it shows evidence of all these assets being transferred into the trust. It's just a nice way to sort of leave things really organized, and maybe simpler for the people who are going to have to take care of things for you if you become disabled or you pass away. So those are that's sort of the summary of the factors. It's about 12:15. That's sort of the end of my formal presentation, but I'm happy to answer any other questions that anybody might have. And Brittany, if you have anything for me, please let me know.
Sure, will do. Thank you, John.
Sure.
Does anyone have any questions? You can type them into the chat. You can unmute yourself and just ask them.
Brittany, maybe I'll unshare my screen.
Sure, yeah, that works. Well, I have one question that maybe can kick us off, and it's
sure.
I think it's a, they say no stupid questions, but it might be. I have heard that when you have a will, any change that you make to it, you have to pay the lawyer to do it, which I suppose makes perfect sense.
Yeah.
Is that true? And or like if you have a will-based versus a living trust one, does that, like if you have a living trust, does that still apply as well? It sounds like with that, like it kind of encompasses more of like the changes that will happen can kind of just happen. But if you know, does that question make sense?
Sure. No, great question. I completely understand. So, of course, this is going to sound very self-serving, but my honest, heartfelt recommendation in either case would be that you do not make any changes to either a will or a living trust without consulting your attorney. For sure, with a will, because of the formalities of a will that are required under the law with notaries and witnesses, you really sort of have to engage the lawyer.
Okay.
But the thing is anytime, these documents are complicated enough and legal enough that sometimes it's hard to know as a person who's not, who doesn't do these things all the time. Like, you don't know how a change you make here might impact a change you make somewhere else. So, there's that issue. And then the other issue is if you start making changes yourself and then there ends up being a problem, there can be some ambiguity about what you intended to do. And that can lead to, fights or problems down the road. So once you get these things in place, if you're going to make changes, it really does make sense to talk to your lawyer. Typically, simple things like changing who you've named to do something, or I want this person to get 10% of my estate instead of 5%. Those are not things that take a long time or are very expensive to do.
Okay, got it. Thank you.
Sure.
It looks like one other question came through in the chat. It says, I am single and have a trust with my son as PR. Would it be better for him to be a trustee?
Yeah, so let's talk about those words PR or personal representative and trustee, because they're similar jobs, but different. So a personal representative is very specifically a person who's named to be in charge of things in your will. A trust does not have a personal representative. A trust has a trustee. An estate in a probate has a personal representative. Now, oftentimes they'll be the same person, right? We talked about this living trust-based plan. So let's say John and Jane Doe create a revocable living trust. They're both the trustees while they're alive and capable. They've named their son Joey as the successor trustee. John passes away, Jane becomes disabled, then Joey is the trustee. So Joey that is his job description, and he is responsible for doing whatever the trust says for trust assets. Now, I mentioned these pour over wills you have in a living trust-based plan. John Doe has named Jane Doe as his personal representative if he passes away and there's a probate, and vice versa. Jane is named John. Well, they both may have named Joey as their backup personal representative. So John passes away. Jane was the personal representative for the pour over will. Now Jane passes away. Joey is the personal representative of the estate, and he is the trustee of the trust. So those are two different job descriptions, two different legal terms, but very similar. So if you're single and you have a trust, Joey should be named the trustee, backup trustee in your trust. And he should also be named the personal representative of your estate, both.
I have a question.
Yes, sir.
Okay, this is from experience. I became the personal representative for my mom.
Yes, sir.
And got really sticky with my siblings.
Yeah.
Is it okay? I've got 4 kids now, and I don't want them to have to go through what we went through. They all like each other right now, but you know, I saw things change fast. So is it better? Is it wise, or is it expedient to have somebody appointed as personal representative that will do this, like they're an accountant? I don't know, somebody totally not related to me and my family, my stuff. Is that done? Do people do that? And if this, how much does it cost?
That's a great question. Is it Larry?
Yes.
Yeah, Larry, that's a great question. So first of all, I hate to say it, but your experience is not that uncommon. When these things happen, sometimes people who've gotten along for forever fight about things that are maybe shouldn't be fought about. So I'm sorry you went through that. Couple things that I would say to answer. I'll directly answer your question, but one other point first, which is I really advise my clients to make sure once they've got their estate plans put together, and presuming their children are old enough to have this type of conversation, to sit down either individually or with the kids and explain, hey, this is what we've done. This is why we've done it.
Okay.
This is how it's all going to work. And if you're going to be mad at somebody, be mad at me, not your brother, not your sister, not your cousin, not who's ever in charge of this thing. These were our decisions, not theirs. So having that sort of family discussion when you get your estate plan done, I think is invaluable in trying to prevent these problems that you experience.
Okay.
But to answer your question, yes, there are professional trustees that do this type of work, both as personal representatives, as agents under financial powers of attorney, and as trustees of these revocable living trusts.
Okay.
Many of the banks have trust departments that specialize in doing this stuff. There are also trust offices, basically just companies that they aren't banks. They just do these types of jobs, either these short term or even a longer term. Say you've got a trust you create for your kids and they're only 5 and they don't get the assets till they're 30. Well, yeah, these trust companies will manage those assets and make the distributions and take care of those kids financially per the terms of your trust. Of course, they charge for these things.
Mm-hmm.
And so some people don't like that idea. Some financial advisors, some accountants, some lawyers will do it. I don't always think that's a great idea. Personally, as a lawyer, I don't do it. Especially wouldn't do it for my own clients. I actually think it's sort of a conflict of interest for me to name myself as a trustee or personal representative of a trust or a will that I'm drafting. But I will tell you, Larry, more and more over the course of my career have I thought that naming, we call them professional fiduciaries.
Right.
Naming professional fiduciaries is something every client should consider for the very reason you mentioned.
Okay, and that's like the first place you mentioned was like go to my local bank and say, do you have a trust department and how do we? And then obviously they're going to cost money, but I think our 4 kids and us are already starting this conversation, so we're kind of done with step 1. Step 2, I think I'll go ahead and advise that we are going to look into that. Now, my son is on all of our accounts, and I will go back and make sure it's the right way, like you talked about. But then now to have a trust, let's say I do have a trustee or a professional person, do I take him off the accounts, or how's that work?
Yeah, I mean, typically, if you have a trust, the idea is you want this other professional to be the one who's doing things, not your son.
Okay.
But it does sort of depend on what your goals are. I mean, some people, they'll have a smaller account with their son or daughter on it just to make sure, just in case something happens, that son or daughter has short-term ability to use some money to pay some bills until the rest can get underway. So there's a variety of different ways you deal with that, and it's sort of on a case-by-case basis.
I get it. Okay, thank you. That
You're
answers
welcome.
questions.
Great. Perfect. Thanks, Larry. We have 4 minutes left before our meeting will cut off. Does anybody else have a question for Jon?
Well, look, everybody. Oh, somebody's jumping on. Okay. Well, and feel free to interrupt, but feel free to reach out to me. My contact information is on that last slide. Brittany knows how to get in touch with me. I'm happy to answer some questions, happy to chat with people, happy to tell you, a little bit more about how I do these things and how much it costs and how we charge. I'm very open about stuff like that. Don't like any surprises. So I would just advise you to think about it and make sure that you've figured out, what it is you think you want and need so that you can get these things in place and be comfortable that you've left things in a good situation for the people who are, coming behind you.
That's wonderful. Thank you, Jon. We really appreciate all your insight and expertise. And
sure.
Like Jon said, I can pass contact info along. So if anybody comes up with any other questions, please reach out to one of us. And as you know, this was recorded. So once we get it kind of edited and put together, we'll send this out to everybody so that you can go back and reference it if you would like to. But other than that, we will go ahead and end it. And just again, thank you so much, Jon. Much appreciated.
Of course. Thanks, everybody. And thank you, Brittany. And thanks to Silverbridge. You guys do a great job.
Thank you. All right. Bye-bye, everyone.
Bye, all.
Thank you for watching this summer speaker series. If you would like to tune in to future presentations or connect with this speaker or Silverbridge CPAs, please visit us online at silverbridgecpas.com.